Okay, good morning, everyone. My name is Shazia Khan, and today's session is on the unit that we'll be doing today is contract law, and we'll be looking at learning outcome 1 today. A little bit about my background. So again, my name is Shazia Khan. I'm the head of law for UK Versity. I've been teaching law now for the last 16 years on both undergraduate programs and postgraduate law programs, and I've got a degree in international law and a master's in law. What we'll do first in regards to doing this unit is we'll be looking at the module specification and then go on to proceeding on to learning outcome 1. So the unit aim, so it's contract law. The unit aim is to will equip any sort of learners with knowledge and understanding of any sort of key principles, such as validity of a contract, terms of contract, things like offer, acceptance, consideration, and in which ways we'll be also looking at in ways in which a contract can come to an end, remedies of breaching a contract, and you will be able to gain an appreciation of the significance and importance of contract law in both commercial, consumer and social contexts. So just looking at the module spec, in order to complete the unit, you must be able to demonstrate achievement of all the learning outcomes at standards specified by the assessment criteria. And as we're going along, you will see the different assessment criteria and the learning outcomes that you're expected to do each week. In this unit, you'll need to demonstrate a practical understanding of contract law, and you should apply it to then your knowledge of any sort of scenarios in place. So where there's an offer, where there's acceptance, and you should apply the elements to that. You should also refer to examples, legislation, any sort of case law, to illustrate any sort of points, which if there's a contract between two parties or if there's consideration, case law will be there to illustrate any sort of examples for you. Suitable scenarios should be provided to learners to allow them to demonstrate knowledge and understanding of all the assessment criteria for pass, merit and distinction grades. All assessments must be in line with the awarding organisation guidance. So the first one we're going to be looking at, which I'm going to go back to the slides, is just to give you an idea, is to learning outcome 1 is to understand the main principles of the formation of the agreements. So now we'll just go back to the slides. Stop sharing out. So as you can see, this is the first learning outcome, and it's on understanding, as I've said earlier, understanding the principles of formation of agreements. So firstly, the aim of the unit, again, to equip learners with the knowledge and understanding of key principles of contract law, as I mentioned earlier. So validity of contracts, offer, acceptance, consideration, and breach of contract and remedies that are available. Again, learners will be able to gain an appreciation of the significance of contract law in a commercial setting, consumer setting and social context. So just a self-assessment on a scale of 1 to 10, rate your current knowledge of contract law. So if you know you're confident about what contract law is, or you don't have any confidence of what contract law is and you need to know more about it. So firstly, we've got the law, and you've got public law and private law. And public law is to do with constitutional, administrative, criminal, and private or civil law is to do with contract, tort, property, trust and family. And if you look at differentiating between both public and private, it's not always easy in regards to, you know, trying to identify which one's public or which one's private. Public law is literally an umbrella term. It includes types of law, as I've mentioned, contract, criminal, public is criminal, and then you've got private law, which is the overreaching of an umbrella, but includes other types of contract law, which is contract, tort, and company and family, as I've mentioned. Key terminology which is important to know if you're doing something on a contract law, which is simply to identify what is a contract. So contract in the simplest definition is a promise enforceable by law. So you promise something to someone else, and you promise, for example, you promise me a car, and then a contract is maybe something that you refrain from doing so you don't give me the car as well. The making of any sort of contract, if you bring the car example, is a mutual assent of two or more persons, one person making the offer and the other one accepting it. And when you look at the elements and the formation of a contract, there are 7 essential elements that you need to be looking at. Firstly is the offer. Secondly, acceptance, meeting of the minds, consideration, capacity, legality, and sometimes a written document. So examples that we've got of different types of contracts. So employment law, employment contracts, and that's a contract between you and the employer to identify what your roles and responsibilities are. And if they breach that contract, you could, have a case in court in regards to an employment tribunal. Then you've got lease contracts, which is a lease agreement between you and the party that is leasing. So it could be a car agreement, leasing a car. Insurance agreements, things like home insurance agreements, and financial agreements, again, to do with your finances, any sort of agreements with banks or anything like that. So there's different types of contracts, but the main 7 elements of a contract are the ones that I've just explained, and in the diagram itself is identified. So what is a contract? What is contract law, and what does it aim to do? So contract law aims to provide an effective legal framework for contracting parties to resolve their disputes and regulate their contractual obligations. The law of contract is more self-regulatory, with the majority of contracts requiring no intervention. The courts make no consideration for whether the contract was fair or not. If it was agreed, it should be enforced. So, a contract between again, the example of the car, if there was a contract there, the courts will only look at that, not whether the contract was fair or not at that time. Despite this, on some occasions, the courts are willing to depart from the principle of contractual freedom. This is often where there's an abuse of bargaining power by one party. So if there's any sort of issues in regards that the court need to take, because they have the discretion to look at each case individually, and if they feel that there's some sort of abuse or unfairness in regards to that, any sort of abuse of bargaining power by one party, then they will, look at it in a different way. So they do have that discretion. What is an agreement in law? Agreement, law and legal definition. Agreement is a meeting of minds or a mutual understanding between two persons, as I mentioned earlier, about the reciprocal rights and duties regarding past or future performances. This can be an agreement, however, not a contract, because it does not create a legal obligation between the parties. What is an agreement in contract law? So, an agreement is an understanding or arrangement reached between 2 or more parties. A contract is a specific type of agreement that by its terms and elements, it's legally binding and enforceable in a court of law. So there will be, if you're in a contract, if you have a contract between me and you again about the car, it's an agreement between me and the other party, and there are terms in the contract that identify, it is a legally binding contract, and if it had to go to court, it's a legally enforceable contract that can go into a court of law in the UK. Examples of standard form contracts can include things like we've got two elements here, which is a unilateral agreement and a bilateral agreement, which we'll go through each one so you're able to identify the difference between each one. Firstly, a unilateral contract is a contract agreement in which an offerer promises to pay after the occurrence of a specified act. An example of a unilateral contract is an insurance policy contract, which is usually partially unilateral. What is bilateral agreement? A bilateral agreement, also called a clearing trade or side deal, refers to an agreement between parties or states that aims to keep trade deficits. It varies depending on the agreement scope and the countries that are involved in the agreement. Bilateral contracts can take some time to finalize. So the bilateral contract is where all parties assume in that diagram, assume an obligation of the contract, and the unilateral one is only one party assumes an obligation under the contract. Agreement against a contract. So what's the difference between each one? So the first one is an agreement is an arrangement usually informal between two or more parties that is not enforceable by law. Again, when we look at contract, the definition is this formal agreement arrangement between two or more parties, but terms and elements are put into the contract and is enforceable by law. So a contract is where, you know, if someone breaches the contract, you could take that person to court and it's enforceable by law and it has terms in it. So a term may be that you cannot do this or you cannot do that, and it has elements of the contract, whereas an agreement is not enforceable by law. It's just an arrangement, informal arrangement. And the validity is based on mutual acceptance by both or all parties involved. And in a contract, mutual acceptance by both or parties involved. Does it need to be in writing? So for an agreement, it does not need to be in writing, and there needs to be no consideration taken. And the legal effect is an agreement that lacks the require any of the elements of a contract has no legal effect, whereas a contract, does it need to be in writing? Again, no, except for some specific kind of contracts, such as those involved on land or which cannot be completed within 1 year. And consideration, again, is required here, which is a monetary consideration or any other form of consideration. And the legal effect is it's a contract, it's a legally binding contract. And it is enforceable in law. So the differences between unilateral and bilateral contracts is in that diagram there, which the table format, which identifies the difference between each one. So the unilateral contract involves only one party is obliged to honour the agreement, whereas in a bilateral contract, two parties are legally accountable to honour the agreement. So this is just a diagram of identifying the different types of elements of a contract. So you've got an agreement, you've got offer and acceptance, which is ITT and termination of a contract. Then you've got consideration, which is a definition, past sufficient, duties. Then you've got domestic agreements. Here you've got the intention to create legal relations. So you identify if there's offer, acceptance, then there's an agreement made, then there's some form of consideration, which could be part payment or monetary consideration. Then there's an intention to create legal relations between it. And then the terms. So if there's any sort of terms you want to agree, you will put that in the contract. Any sort of conditions, warranties, anonymities, and these will bound the contract together and identify that there is a contract made. Then you will have exclusion clause, common rules, and statutory rules. If the terms are breached in a contract, this diagram identifies, then you will be awarded damages or other remedies, which is specific performance or any sort of injunctions or anything like that. So you would, if a contract is breached, you would be awarded the damages. And in breach, we say that, you know, in regards to the terms, if the terms are breached and they're not followed, then damages and other remedies are awarded. So the law of contract. This has developed over years from decisions of judges to regulate how businesses should be done. It helps to reduce conflict and ensures that business transactions are conducted in a formal manner. So components of law of a contract. So firstly, how is the contract form, the formation is really important. How does an individual create a legal binding contract with another? And what may prevent an agreement operating as a contract? Then we've got privity of a contract, which is exactly who our contractual obligations owed to, which party. Construction, so what kind of obligations can be included in a contract? The mitigating factors when a contract can be void or voidable. The discharge of obligations, at what point are the parties free from the contractual obligation? When can they opt out of this obligation? And then remedies, what are available. So now we're just going to watch a video in regards to contract law formation. This looks at what is a contract.
Contracts are everywhere, not just some huge formal agreement between large corporations where one is going to buy the other, so on, although that's what something like that looks like. But you know, as a matter of fact, it's everywhere. You go through them, I don't know how many times in the course of a day. You go into a parking garage, they give you a stub. Now, that's a contract. They're going to look after your car, more or less, and you're going to pay them. You walk in to your dry cleaners and you drop off your suit, and the person behind the desks gives you a receipt. Well, that's important because that's how they're going to know which suit is yours. But that receipt is also a contract. And even if there wasn't a receipt, you're dropping it off there and coming back a couple of days later and picking up the suit. Well, they expect to get paid, and you expect to pay them. That's a contract. You walk into a restaurant. You order the steak and chips and everything else, and then you get the check and you pay it. You can't just say, well, that's very nice, thank you very much for dinner, see you tomorrow. Understood between you was they're going to feed you and you're going to pay them. And so it goes. But it gets even less formal than that. I live in New England, and we have a lot of snowstorms in the winter. So what happens? It snows, and a bunch of local kids come, knock on your door, and say, sir, can we shovel out your driveway and your walkway and so on? How much? $20. Okay. So they do it, and then they knock on the door, and they have a contract with you. You owe them $20. They didn't do that as a favor. Now it gets more complicated. You're out of town, and it snows. And while you're out of town, they come and they shovel out your driveway and do all that. And when you come back and they say, $20, please. Well, do you have a contract for that or not? We'll find out later whether you do or not. And what if it snows the way it did a couple of years ago, 18 inches? And they say, well, you know, we had a lot of work to do, and they really did. This time you owe us $30. Do you owe them $30? All that is something we're going to try to understand. Now, you might ask, why do we have a MOOC on this? Why am I asking you to join me for really quite a number of sessions and quite a lot of work, your work, my work, on the subject of contracts. One thing I'm going to tell you, I'm not going to turn you into lawyers. I'm not going to teach you how to draft a contract or deal with a situation where somebody sues you or claims. That's not what I'm going to do. What I'm going to do is for you to understand what's going on as you go through your lives in a jungle, or maybe not a jungle, a forest. It's not so unfriendly, of contracts. It's as if I were offering to teach you a course on the internal combustion engine. Now, this wouldn't be a course on how to fix your car when it breaks down or doesn't break down, but to know what's going on under the hood. So if your service station then tells you it's the transmission and that's going to cost you $1,500, you know what the transmission is, and you know whether it kind of makes sense for that to cost you $1,500. In other words,
Just to share some elements of that video with you. In regards to that video, it was there to identify what is a contract, because some people are unaware of what a contract is. And it looked at the good examples of a dry cleaners where you go in and give some clothes in, and there's a contract form there that you have the expectation, that they have the expectation that you're going to come back and collect the clothes and then pay for them. That's a contract itself. Again, another example, again, if you give your car in to get repaired, you have the expectation that it will be repaired, and the other party has the expectation that they will pay for the car, and that is a contract. Another good example is the one that he used in regards to the restaurant. You have the expectation that you're going to go there and eat, and then there's an offer where you've looked at the menu and ordered something, and acceptance will become an element of the contract. And then the consideration part is where you pay for the food that you've eaten. Okay, so there's so many elements that you could look at when you look at examples of a contract. 1.1, now we need to distinguish between an offer and an ITT, which is an invitation to treat. A contract is described as a legally binding oral or written agreement with exchanges of any combination of goods, services, money, and property. And as we mentioned, food, dry cleaners. It is a common misconception that contract may be only written form, as oral or conduct agreements can be as credible in contract formation. So even if there's a contract, like we said, in the restaurant between you and the waiter, excuse me, that is a contract. It doesn't have to be in a written form. A contract is unique in that that unless certain exceptions apply, parties are free to agree to whatever terms they choose. This is known as freedom of a contract. For example, in buying groceries from a supermarket, you have entered into a contract for the exchange of money in return for them goods. This is an example of a very simple contract. An offer. The formation of a contract involves one party making an offer to another. So an offer can be made orally, in writing, or by action. It must be clear, complete, and it must be communicated to the person to whom the offer is being made. So the offerer is the person making the offer. The offeree is the person receiving the offer. An offer can be terminated in the following ways: if it is rejected by the offeree, withdrawn at any time by the offerer before acceptance has occurred, and if the time of acceptance has expired. So a contract begins with an offer. So the offer is an expression of a willingness to contract on certain terms. So that is an offer for me to say I'm willing to get into a contract for a lease, for a finance car, and there are certain terms that need to be applied to, okay? It allows the other party to accept the offer and provides the basis of an agreement. So then if the finance company comes up, the lease company comes up with a certain terms and agreements of the contract, then that is where it firstly becomes an agreement. An offer exists whenever the objective interference from the offerer's words or conduct that she intends to commit herself legally to the terms she proposes. This commitment occurs without the necessity for further negotiations. The first step in finding a contract is to establish that there's an offer and who is making the offer. Many communications will lack this necessary intention and thus not be offers. There may be statements of intention, supplies of information, or again, like we said, invitations to treat. An invitation to treat is an indication of a willingness to do business. It is an invitation to make an offer or to commence negotiations. Courts have considered whether or not a communication was an offer or invitation to treat in a wide variety of circumstances. And this is quite popular because this identifies if there's an offer or if there's an ITT, which is invitation to treat. So goods displayed in a window or on a shelf. When a book is placed in a shop window priced at £7.99, the bookshop owner has made an invitation to treat because he is inviting everyone to have the book or purchase the book. When I pick up that book and take it to the till, I make the offer to buy the book for £7.99. When the person at the till takes my money, the shop accepts my offer. And when the shop accepts my offer, then there's a contract which comes into being. So firstly, there's an invitation to treat where he is advertising literally the book in the window, and then you come in, you pick up the book. That is an offer that you've made because you go to the till and you want to pay for it, and then that's when the shop actually accepts the offer and a contract is made. For example, of an invitation to treat is a display of goods is generally an invitation to treat, as we mentioned in the example for the book. And the case of this was the Pharmaceutical Society boots. And the main rationale behind treating the display as an invitation to treat rather than as offer was the case of Fisher and Bell. In contrast, where the display is made by a machine, the display would probably be an offer. And that's the Thornton and Shoe Lane parking case. And a lot of these additional information on these cases are available on Moodle for you to look at. In the case of Partridge and Crittenden, 1968, an advertisement in a magazine stated Bramall Fitch cocks and hens 25 shillings each. As the Bramall Fitch was a protected species, the person who placed the advertisement was charged with unlawful offering for a wild bird, contrary to the Protection of Birds Act 1954. But his conviction was quashed on the grounds that the advertisement was not an offer, but an invitation to treat. It was held that in Granger and Sons and Goff, 1896, that the circulation of a price list by a wine merchant was not an offer to sell at those prices, but merely an invitation to treat. Elements of a legally binding contract. Acceptance. This is where the offer is accepted. It is binding on all the parties. The offer must be accepted with all conditions. Sometimes an offer may be accepted subject to conditions. This is called conditional acceptance. So, where you've agreed some sort of conditions and you want to put them conditions into your contract. Consideration, this is something of value offered by a party to a contract in exchange for something of value received. It usually takes the form of money in exchange for goods and services received. Then you've got an intention to contract, which must be the intention of the parties to create a legally binding agreement. Personal agreements are not legally binding. If there's an agreement by two people to go to the cinema, then one person does not turn up, that person cannot sue because there's no intention to create a legal contract. Capacity to contract. So in order for a contract to be a valid contract, the parties must have the legal right to do so. Some people do not have the legal right to enter into contracts. These include companies acting ultra vires, and that means beyond their powers. A firm's power is said to be limited by its objectives in the Memorandum of Association. So if there is a breach, the directors have no capacity to the contract, and that's acting beyond their powers, any sort of business. And then a person under 18 cannot enter into a contract except for the supply of necessaries, goods they actually need. And then also in regards to a person under the influence of alcohol cannot enter into a contractual agreement because they are under the influence and they're not in their right frame of mind. A person of mental illness has no capacity to a contract. Again, someone who has any sort of mental illnesses or who has who's of unsound mind, then a bankrupt person cannot enter a contract that is legally binding. And a diplomat is a person of position privilege. If they break a contract, they cannot be sued or prosecuted as they plead the diplomatic immunity. Consent to a contract. So the parties to a contract must agree to its terms. They must both agree on what is being sold or bought and the price. So there is an agreement between both the parties and there is acknowledgement of acceptance of that agreement. So that is consent. The parties will be entering into the contract voluntarily. So no person should be forced into making a contract. So any sort of undue duress or anything like that. Legality of form, so a contract must be drawn up in the legal form. Contracts can be oral, but certain contracts must be written. For example, hire purchase agreement and any sort of insurance policies on a car or a house. Legality of purpose, they should have to be for legally binding contract and not involve committing any crime or breaking the law. 1.2, you look at identifying and explaining the legal rule applicable to acceptance of an offer. So termination of a contract. A contract can be terminated by performance, breach, agreement, or frustration. First one is performance. So here, when parties to the contract have carried out their side of the contract as agreed, very common way to end a contract. For example, a contract to perform a concert. When the concert has ended, the contract is over between both parties. Breach, number 2, is one party to the contract has failed to perform their obligations in the contract, so breach of a contract. This entitles the injured party to abandon the contract and sue for damages. Breach of warranty allows the injured party to sue for damages. For example, wrong colour of a car being delivered is a breach of contract. So if you've agreed a contract with Vauxhall or Golf to get a car that is red colour and you get a white car, then that is a breach of contract because they've breached the contract and also the terms of the contract. Number 3, an agreement. When the parties to a contract agree to end the contract. For example, if a garage couldn't get a particular car for a customer and they had tried all avenues, then both parties agree to enter contract. And that's between both parties. So it's not something that's intentional or it was a breach of anything, okay? Frustration. If an unforeseen event occurs and makes the contract impossible, it is terminated. This frustration can also relate to death, bankruptcy, or lapse of time. For example, if there was a fire in a garage and cars were destroyed through not one's fault, then contracts can be terminated. So because of it wasn't the fault of any parties, then at that time contracts could be terminated. An offer is made when a person shows a willingness to enter into a legally binding contract. An invitation to treat, which is referred to as ITT, is merely a supply of information to tempt a person into making an offer. Things like if there's something in the window, which was a good example of the book, or a toy that a child wants, that's an invitation to tempt that child and for him to tell his parents that he wants that car or doll or anything like that. When misinterpretations and complications occur, then it is down to the courts to decide and distinguish between the two terms. So a person is not led into a binding contract of which he does not want to be part of, but it is merely supplying information to an offer is to be made. And that's in the case of Harvey and Facey, 1893. And in this case, Harvey and Facey, 1893, Facey was in negotiations with the Mayor and the Council of Kingston regarding the sale of his store. Harvey, the plaintiff, sent Facey a telegram stating, "Will you sell us bumper haul pen? Telegraph lowest cash price paid." On the same day, Facey sent Harvey a reply by telegram stating, "Lowest price for bumper haul pen, £900. Harvey sent Facey another telegram agreeing to purchase the property at the asking price. D refused to sell, and P sued for specific performance and an injunction to prevent Kingston from taking the property. The trial court dismissed on the grounds that an enforceable contract had not been formed, and P appealed. The Supreme Court of Jamaica reversed and D appealed. The issue in this case was that is a statement of the minimum price at which a seller would sell an offer, and the holding in the rule in this case, no. A mere statement of the minimum selling price is an invitation to treat and not an offer to sell. The court held by replying to P's question regarding the lowest price of the property, D did not make an affirmative answer to the question regarding this willingness to sell. The court held that D had made an invitation to trade, not an offer. Another difference between an invitation to treat and an offer is an invitation to treat is an action inviting other parties to make an offer to form a contract. So it's not literally an offer. So it's you are tempting the other party to come in and make this contract. These actions may sometimes appear to be offers themselves, and the differences sometimes can be difficult to determine. The distinction is important because accepting an offer creates a binding contract, while accepting an invitation to treat is actually making an offer. Advertisements are usually invitations to treat, which allow sellers to refuse to sell products at prices mistakenly marked. Advertisements can also be considered offers in some specific cases. Auctions are sometimes invitations to treat, which allows the seller to accept bids and choose which to accept. However, if the seller states there's no reserve price or the reserve price has not been met, the auction could be considered an offer accepted by the highest bidder. The main cases relevant to offers and invitation to treat is the case of Carlin and Carbolic Smoke Ball, 1893, a very famous case on ITT. Fisher and Bell, the flick knife case, 1961. Pharmaceutical Society of Great Britain, and Boots Cash Chemist, 1953. The Carbolic Smoke Ball, again. Have a look at these cases. The facts of the cases and additional reading is on Moodle for you. And literally here it identifies a little bit briefly about the case of the first one, which is the Carbolic Smoke Ball, 1893, where the defendants were the marketers of smoke balls, which they claimed could prevent influenza. They published an advertisement stating that if anyone used their smoke balls for a specific time and still got caught the flu, they would pay that person £100, and they would need to prove they were serious about the claim. They deposited £1,000 with their bankers. Mrs. Carlisle bought and used a smoke ball, but then nevertheless ended up having a flu. She therefore claimed the £100, which the company refused to pay. They argue that the advertisement could not give rise to a contract, since it was impossible to make a contract with the whole world, and therefore they were not legally bound to pay the money. This argument was rejected by the court, which held that the advertisement did constitute an offer to the world at large, which became a contract when it was accepted by Mrs. Carlin, who used the smoke ball and still got the flu. She was therefore entitled to the £100. A more recent illustration is provided in the case of Bowerman and Association of British Travel Agents, 1996. A school had booked a skiing holiday with a tour operator, which was a member of the Association of British Travel Agents, ATHE. All members of this association display a notice provided by ATHE, which states where holidays or other travel arrangements have not yet commenced at the time of failure of the tour operator, ATHE arranges for you to be reimbursed with the money you have paid in respect of your holiday arrangements. The tour operator became insolvent and cancelled the skiing holiday. The school was refunded the money they had paid for the holiday, but not the cost of the wasted travel insurance. The plaintiff brought an action against ATHE to seek reimbursement of the cost of the insurance. He argued, and the court agreed, that ATHE notice constituted an offer which the customer accepted by contracting an ATHE member. A contract arising from an offer to the public at large, like in Carlisle case, is usually a unilateral contract. 1.3. Assess the requirements for a valid consideration. Consideration is in a contract law is simply the exchange of one thing or for value for another. It is one of the 6 elements that must be present for a contract to be enforceable. Consideration must be both legally sufficient and bargained for by receiving party. What makes the contract enforceable? They say a rose is a rose. They say a rose is a rose is a rose, and for the most part that is true. But in contract law, a contract is not always a contract. In other words, a contract needs 6 elements to be considered enforceable. An offer made by the promisor, an acceptance of the offer by the promisee, consideration in the form of money or promise to do something or not do something, mutuality between parties to carry out promises of the contract, capacity of both parties in mind and age, and legality of terms and conditions. So consideration, as we learned, is simply something of value exchange between the parties. To the contract, qualified consideration must be legally sufficient and bargained for. That is to say, the value of the promisor places on the consideration must be of the same value the promisee places on performance of the contract. In other words, both parties want to know what's in it for them. To illustrate, if John, the promisor, offers Jamal promisee £200 to repair his car, and Jamal accepts the £200 is consideration, which is the value, and then the performance in this is for the repair. There are conditions considered. Consideration has to meet to have a legally sufficient value. A party cannot promise to do something where there's already a legal obligation to do it. A police officer cannot collect a reward for the capture and arrest of an outlaw. The promisee must perform an act ordinarily obligated to perform. A police officer cannot contract independent security services for his neighbourhood while he's on a duty at his regular job. He has a pre-existing obligation to secure the neighbourhood. Finally, for consideration to be legally sufficient value, a party may refrain from exercising a right that the party is entitled to, like giving up the right to sue someone in exchange for restitution. For instance, let's say that in fixing the car, Jamal dented John's fender. Jamal apologizes and tells John that he will fix the dent for free and also gives him 10% discount on the original repair. If John accepts the deal, he cannot later sue Jamal for denting the car. Consideration also must be bargained for, meaning there's an exchange of promise and something of value where both parties gain a reward and receive a detriment in the contract. It's simple. Let's say John and Jamal are now negotiating the sale of a bicycle that has displayed in the auto repair shop. John wants to take up biking, so he offers £50 to Jamal in exchange for the product. Jamal will give the bike to John upon receipt of the cash. So both parties bargain and receive a detriment. John's bank is reduced by £50, but he's received some new wheels. Jamal no longer has the bike, but has an extra £50. 1M1, critique of the significance of practical benefit as consideration. So this is if you want to do the extension activities, and you would do this 1M1. What is practical benefit in contract law? Factual benefit is describing consideration in a traditional sense. It means that the promisee must be getting something more than what he already has legally entitled to. Practical benefit is describing consideration as in the case of Williams and Roffey sense. Why is Williams and Roffey important? In debt cases, the law pulled in 2 different directions. Williams and Roffey suggest that a practical beneficial could constitute the consideration required to bind a creditor to their premise not to sue for the rest of the debt. 1D1, now this is if you want to get the distinction side, the extension activities, you need to assess the limitations of Williams and Roffey Brothers 1991 in relation to a promise to accept less. Williams and Roffey, Williams was engaged to refurbish a block of flats. The contract between Williams and the property owners contained a penalty clause. Williams would have to pay the fine if the refurbishment was not completed by a specified date. Williams engaged Roffey Brothers to perform carpentry work in the flats. Unfortunately, Roffey Brothers ran into financial difficulty and admitted that they'd be unable to finish the job. This was bad news for Williams. The delay associated with finding another carpentry firm risked triggering the penalty clause. To avoid this, Williams offered Roffey Brothers £5,000 to ease their financial troubles. This payment was accepted and the flats were completed in time. Yet, when Roffey Brothers sought the £5,000, Williams refused to pay. Williams argued that Roffey Brothers had provided no consideration to support the promise of extra payment because by promising to complete the carpentry work, Roffey Brothers were doing nothing that they were not already contractually obliged to do so. The Court of Appeal disagreed, and the court held that Williams enjoyed various practical benefits by reaching an agreement with Roffey Brothers. Most obviously, the agreement saved Williams from triggering the penalty clause. The court held that these practical benefits constituted valuable consideration, meaning that Williams was legally bound to his promise to pay the £5,000. Williams and Roffey Brothers it was leading case in English contract law in 1989, and it was decided that in varying a contract, a promise to perform a pre-existing contractual obligation will constitute good consideration so long as benefit is conferred upon the promisee. There was a departure from the previously established principle that promises to perform pre-existing contractual obligations could not be good consideration. As we mentioned, the facts of the case, Roffey Brothers was contracted by Shepherd Bush Housing Association to refurbish 27 flats at Terhome Mansions, Little Lily Road, London. They subcontracted carpentry to Mr. Lester Williams to £20,000 payable in instalments. Some work was done, £16,200 was paid. Then Williams ran into financial difficulty because the price was too low. Roffey Brothers was going to be liable under a penalty clause for late completion, so they had a meeting on 9th of April and promised an extra £575 per flat for a time completion. Williams did 8 flats and stopped because he had got £1,500. New carpenters were brought in and Williams claimed, and QC Rupert Jackson held that Williams should get the 8 times £575 with a few deductions for defects in some of the £2,200 owing from the original sum. He said that they had agreed that the original price was too low and that raising it to a reasonable level was in both parties' interests. The judgment and Lord Justice Glidewell said that Williams had provided good consideration even though he was merely performing a pre-existing duty. Williams got £3,000, £3,500, not full expectation damages. He said that the idea of promissory estoppel was not properly argued and not yet fully developed. The concept of economic duress provided an answer to Stilk's old problem. An agreement to perform an existing legal duty cannot constitute good consideration for a contract. The test for understanding whether a contract could legitimately be varied was set out as follows. If A has a contract to employ B for work, before it is done, A has reason to doubt whether B will or be able to complete the side of the bargain. A promises to pay more. A obtains a practice, a benefit, or obviates a disbenefit from giving the promise. There's no economic duress or fraud. The practical benefit of timely completion, even though pre-existing duty is performed, constitutes good consideration. So how did Williams and Roffey's change the law? Roffey, as it has seen, is out of date in courts. This step away from Silk and Myrick shows how decision in Williams and Roffey challenged the traditional rules of consideration, such as the pre-existing duty to principle, and established a path that the rule of consideration could take. What was decided in the case of Williams and Roffey is a leading case in contract law. As we've stated earlier, it decided that varying a contract, a promise to perform a pre-existing contractual, would constitute good consideration as long as benefit is conferred upon the promisee. So the contract there, acceptance, offer, then you've got end of specified time, end of reasonable time, failure of pre-condition, the rejection, counter offer, death of offerer, death of offeree, and withdrawn. Here is a quiz that you could do in regards to, in your own time, in regards to a contract law, and it is on Kahoot, so you just link onto that to get onto the quiz. To help you, can just show you how to get onto that, and it is a quiz that so just get onto that in your own time if you want to use it, so you have to log into it. References that we've used in regards to today's session is e-law resources paste on contract law, legalcheek.com on the William and Ruffy brothers case, tutor2u net papers, and difference between businesses and difference between unilateral and bilateral contract. So please try to go on to Moodle to get any sort of additional resources that will help if you're reading up on the cases, and try to get on there for any sort of additional information as well on the cases, but also read up around the cases, and go online and try and do that quiz as well, which will help you trying to identify how a contract is formed. Now we've looked at the learning outcome 1. The next learning outcome we'll be looking at, which will be learning outcome 2, which is to understanding the rules that govern the content of a contract. So today's session is finished, and thank you for attending the session. If you have any questions, please email me. Thank you.